Good afternoon, everyone. Welcome to the meeting of the Committee on Economic and Community Development, and we do have a quorum. We are here this afternoon for Bill number 21-0031, Landlord-Tenant Lease Renewals. In attendance, we have the members of the committee, Councilwoman Sharon Green Middleton, representing the 6th District, also Vice President of the Council. We have John Bullock, member of the committee, representative of the 9th District.
Thank you, Madam Chair.
We have Ryan Dorsey, member of the committee, representative of the 3rd District. We have Robert Stokes, member of the committee, representative of the 12th District.
Madam Chair.
And I'm checking for other members that might have appeared, but we still have a quorum. Moving on, checking to see if there's any other council members present that are not members of the committee. And I see none. Members of the Office of the President, I see Nikki Thompson. I see Lucy Font. I see Matt. You're welcome. I see Matt Stegman. And I see Aaron DeGraffereed.
Thank you, Madam Chair.
Members of the Office of the President. And I also have Matt Peters here with me today, representing Council Services. Representing the Mayor's Office, I see Nina Thimulus.
Thank you, Madam Chair.
And I also see Natasha Mihu.
Thank you, Madam Chair.
You're welcome. And before we begin, just a few housekeeping things. If you're not speaking, please keep yourself on mute. Please do not take yourself off mute unless you are recognized by the chair. When you are recognized, please identify yourself and the organization or agency that you are representing. Once you finish speaking, please put yourself back on mute. Let's begin. Bill number 21-0031, again, landlord-tenant lease renewals for the purpose of requiring, absent certain good cause circumstances, landlords to offer tenants a reasonable opportunity to renew leases, providing for the manner of notice for which a landlord must send renewal notices or decline to renew notices, establishing a presumption to offer and offer and acceptance, absent certain circumstances, providing for the effect of the subtitle, providing for certain administrative and criminal penalties, and providing for a special effective date. This bill was introduced on January 25th, 2021, and the bill was sponsored by Councilman Glover. And Councilman, he's the sponsor of the bill, but Councilman Glover is not with us at this moment. So I want to recognize Nikki Thompson if she has any comments before we start on behalf of Councilman Glover from the Council President's Office.
Thank you, Madam Chair. Actually, Councilman Glover's staff is on, and I think we're trying to get them elevated to.
They should both be up now.
Wait.
Hi, Nikki. I think we're on now.
Wonderful, thank you.
Hold on 1 second, Sean. Am I supposed to speak now? Yeah, go ahead.
And while we're
Want to
waiting,
share, go ahead,
What?
sorry.
okay, I just want to also recognize a member of the committee, Odette Ramos just came on from
Thank
the
you, Madam
14th
Chair. Good
District.
afternoon.
You're welcome. And also recognize member of the committee, representative of the 4th District, Councilman Mark Conway.
Thank you, Madam Chair.
Statement here, Tony sent.
So at this point, Councilman Glover's office, was there someone
I got it.
that was going to speak? I can't, you must be on mute.
Hi, good afternoon, ladies and gentlemen of the committee, Chairwoman Middleton. I am Jamal Simpson, Council Assistant for Councilman Glover's office. And I do have a statement from Councilman Glover to read today. No doubt, COVID-19 has created a looming housing crisis across America, but it only compounds the housing crisis that has already existed in Baltimore City. Over the years, rental rates have steadily increased while wages and income have remained stagnant. Many citizens who already require more than one income to meet their monthly rent and bills were crippled by COVID-19 shutdowns and the loss of jobs that have yet to come back. While hospitality and tourism remain staples in Baltimore's economy, many of those jobs have yet to return, all in the name of public safety. That said, many tenants fell behind in rent, struggling to survive with Congress playing games of relief efforts and a failed rollout of, and maintenance of the state's unemployment portal. Even with the relief bills that have been rolled out by our federal government, many citizens are finding issues navigating the unemployment website. For someone that has fallen several months behind in rent and utilities, stimulus checks alone could not help them keep their head above water. Graciously, the federal government and state government imposed eviction moratoriums in an effort to keep people housed safe during the pandemic, but yet a loophole in those executive orders which contribute to the looming there are loopholes in the executive orders which contribute to the looming housing crisis. This loophole allows landlords to refuse to renew a lease at the end of its term without giving cause. This bill proposed by Councilman Glover seeks to close that loophole, giving otherwise good tenants an opportunity to catch up on their rent and retain housing in an effort to keep families from going homeless in these trying times. This bill still allows lease non-renewals due to conduct detrimental to the landlord's property, but does not allow lease non-renewals simply for non-payment of rent. This bill is not a permanent ban on lease non-renewals due to non-payment. This bill is to provide some relief to the housing crisis during the state of emergency. Laws like this aren't foreign in the US. Bills like this have passed in Atlanta, Philadelphia, Washington State, California, and right here in Maryland and Montgomery County. In conclusion, in a city that has been ravaged with a housing crisis over its history, systemically targeting our Black and brown families, it is time to act, to make a decision to choose some of our most vulnerable people at this critical moment in our history. Thank you.
Thank you. Thank you for representing your councilman. And just a note, Councilman Glover is very much under the weather and not able to join us. And his staff has taken on that responsibility just to share his voice. So Jamal, thank you so much for that. And I also want to recognize Councilman Costello has joined us for the hearing. He represents the 11th District.
Thank you, Madam Chair.
We will now hear, the committee will now hear from the agency representatives. And remember to please state your name as we go through the agencies. And we'll start with the city solicitor. City Solicitor's Office. Do I hear a representative? Let me see. And I don't see anyone on Natasha or Nina, did you?
Yes, Madam Chair, I see Hillary Rowley is in, but as an attendee, if she could be elevated.
Okay,
Thank you.
thank you. We're elevating her now.
Can you hear me now, Madam Chair?
Yes. Hi, Hillary.
Great. This is Hillary Rulli from the Law Department. We certainly appreciate the goals of this legislation. In Maryland, state law guarantees landlords the right to evict people at the end of the lease. The city, even during a pandemic, can't enact a law that says otherwise. In fact, the city tried this in past, was taken to court, and the law was struck down, saying that the state law leaves no room for local governments to say when a landlord gets to evict a tenant at the end of the lease. And as Councilman Glover's staff person made everyone aware, the governor's office actually has put out executive orders preventing evictions, and they decided not to include this in the list of people who could be saved from eviction. And that's the final word in Maryland. Unfortunately, no pandemic gives a local government the ability to go against a state law. We've certainly tried it in the past for this exact thing. The court has said no. It's also important to note that when the pandemic started, the governor had an executive order that gave local governments the power to suspend even state laws. And so we could have acted at that time to suspend the effect of a deadline in a state or local law. The governor got rid of that executive order power a couple of months ago and took that away from local governments. So it is perfectly clear here that this will not be legal. In addition, it will likely not help any tenants, because when they go to rent court and say their lease is over, that rent court isn't going to be looking at this local law. If they did and they upheld it, the landlord would clearly win in court. It might intimidate landlords and tell them they can't evict people right now, and they might be scared to do so. But it will not actually require them to renew the lease, and it won't help tenants. Thank you.
Thank you. And I'm going to go through all of the agencies, and then we can come back. The Department of Housing and Community Development.
Yes, good afternoon, Madam Chair. Thank you. Stephanie Murdoch, Legislative Liaison for the Department of Housing and Community Development, reporting in on 21-0031. We stand by our bill report, which we defer to the Law Department on the passage of this bill. DHCD recognizes that many Baltimore renters struggle to pay for housing, leaving their families at risk of instability and even homelessness. This bill may provide additional housing stability for Baltimore's renters. However, as stated in the Law Department report, it is in conflict with state law. DHCD supports the administration's efforts around this issue, and should the bill be amended to meet legal sufficiency, would welcome the opportunity to continue the conversation with our sister agencies around the passage of this bill. Additionally, as I mentioned in our bill report, this legislation provides for enforcement by issuance of an environmental citation. It is unclear if this type of enforcement would be practical or possible by any city employee who is authorized by their agency head to issue environmental citations. So thank you for your time, and we stand by our report.
Thank you. Thank you, Stephanie. Housing Authority of Baltimore City, and I think I see William Wells.
Good afternoon, Madam Chair. Bill Wells, Senior Vice President for Business Strategy for the Housing Authority of Baltimore City. The Housing Authority declined to submit a formal response to this bill. We understand, after seeing the Law Department's response and the other agency responses, we had understood that there were amendments in process. We wanted to hold our response so that we could specifically comment on the amended legislation. I would say, however, that under the two programs that the Housing Authority operates, public housing and the Housing Choice Voucher Program, there's slightly different impacts to the idea of this legislation. If it would be permissible for me to go into that a little bit, I would be happy to, for the committee, for whatever their deliberations would be later in this session.
Okay, we'll hold on and
Sure.
come back to you.
All right, thank you.
You're welcome. The Office of the Sheriff, I see Major Sabrina Tapp Harper.
Yes, ma'am. Good afternoon.
Good afternoon.
Yeah. Okay.
Yes, we can hear you.
I have a letter from the Office of the Attorney General from Sheriff Anderson. The Honorable President and members of the Baltimore City Council. Dear President and City Council members, on behalf of the Baltimore City Sheriff John W. Anderson, I write to advise that the Sheriff has reviewed Bill 21-0031 and takes no position on the proposed legislation. Upon review, Bill 21-0031 does not impact the Sheriff's performance of his constitutional duties, and in particular, it does not impact the Sheriff's service of warrants or restitution for evictions. In addition, the Sheriff defers to the city's law department legal analysis of the proposed legislation. Sincerely, Carl N. Zacharias, Assistant Attorney General. Thank you.
Thank you. Thank you for your testimony on behalf of Sheriff John Anderson. Finance Department.
Good afternoon, Mara James, Legislative and Engagement Lead for Department of Finance. We stand by our report. We defer to law on this bill about the actual legality of being able to enact or enforce this legislation. Thank you.
Thank you. Nikki Thompson, did you want to speak at this time?
Thank you, Madam Chair. I will actually defer first to our General Counsel, Aaron DeGraffenreid, if you wanted to, Madam Chair, actually begin the process of maybe doing any follow-up responses, but I'll defer to how you would like for us to proceed. And if that is the case, if we're moving into responses, then I'll turn it over to our General Counsel.
Let's start with the General Counsel.
Thank you, Madam Chair, and good afternoon, ladies and gentlemen of the committee. As we have worked on this, the legal issues with this bill, we appreciate the thorough analysis that we've had from the law department in our conversations back and forth with the law department on this matter, and the legal issues that Ms. Ruley outlined for us. With respect to the, as one of the attendees mentioned, we are planning to have some amendments to tailor to plan this bill to be tailored to the state of emergency. And one of the sources of authority that we find persuasive is contained in the CDC eviction moratoriums, which are federal and supersede the state. And so those are some of the amendments that we believe will be able to help this bill to overcome some of those legal issues and survive challenge. And with that, I will, I guess, turn it back to Director Thompson.
So before we do that, just want to understand that there's going to be some amendments to submit because of the state of emergency to help clarify some of the law department's concerns. And I guess, Nikki, you're going to give a little bit more of that in detail?
Yes, thank you, Madam Chair. We have done just one moment, Councilmember Bullock says he needs to be elevated. I'm not sure if we saw that message.
Oh, I didn't. He must
No
have
problem.
dropped off.
Well, to continue, again, appreciate all of the thoughtful analysis that has been put into not only just the legislation, but further the legalities around this legislation. As previously mentioned by Councilmember Glover, we are in a novel time. And so it is important for us as legislators to push and make sure that policy is working practically for people. And so that is, I think, what we all have the same outset to do and what we all plan to do. And so given the prior conversations that we've had, not just with the law department, but also with our general counsel and some other stakeholder groups, we understand that a number of amendments are needed to make sure we can get this to a workable solution for Baltimore City residents. And so we are excited to go down that path. And I think that there are some other amendments that will be brought up as well. So just want to use this time to discuss the amendments, share some more analysis, and then we can move forward from there.
Okay. I'd like to hear those amendments, and then we'll get to the outside attendees that want to testify as well, if you want to follow that format.
That works, that's fine.
Okay.
So first, as General Counsel laid out, we are looking at tailoring the legislation to the state of emergency, tying it to the CDC, which is federal and superseding policy. And then additionally, we know that there are some concerns about the language that specifically speaks to failure to pay rent during the state of the pandemic. There is additionally an executive order that allows for the affirmative defense if you can show that you have lost income due to COVID, being able to use that defense and also apply that to this legislation. So that way we are not still having a loophole within trying to close this loophole has also been brought to our attention. Those are the two main amendments that we are planning to explore further. And so if there's anything that you would like to add, General Counsel, please feel free.
I don't have anything else to add at this time. Only like we've said, the amendments that we're going to continue to work on and continue to be in consultation with the law department and the stakeholders on. We feel good that we're going to be able to put together something that we'll be able to hold up.
Okay, and then on that note, we're still going to hear testimony from some more people, but it definitely seems like we're going to go in recess and come back for a work session with those amendments, with a date for those. So that's good to hear that there are two amendments coming that will kind of help with some of the concerns of the law department and others. So are there any questions at this point? Please use the raise hand function from the committee.
I do also just want to note, Madam Chair, that because it might be a question, we have not drafted these amendments yet. So for the committee members who have not seen them, please do not, or agencies, please give us a moment while we put them together.
Right, because I haven't seen them as well. So thank you for that. We'll start with Councilman Dorsey.
Thank you, Madam Chair. My question for the law department is, I believe I understand the analysis of the state law. If I could try to reiterate this to make sure that I understand it clearly. Basically, because the state law says that a landlord has a right, an unequivocal right to evict a person at the end of a tenancy. We can't do anything that would make them take any action otherwise, including a pre-agreed upon continuation of tenancy, right?
Hillary, did you want to answer that? Hillary, are you there?
Madam Chair, Mina Themos with the mayor's office. It looks like she was back down on the attendee list and may need to be elevated again.
Okay.
Can you hear me now, Madam Chair?
Yes, thank you. Could you comment on?
Yes. Sure. Yes, actually, that's exactly right. In a lot of cases, if the state is legislating, local governments can too. So the city tried this and they said in the city, we want a different policy. They passed a law saying that at the end of the lease, a landlord has to work with a tenant. And the court struck it down because they said that actually Maryland law guarantees the landlord the right to take back possession when the lease is over. And I appreciate the desire to fix this, especially during a pandemic. Unfortunately, in America, all the power lives with the states. So even
We lost you.
It sounds like we're having a hard time hearing you. Just so I get that. So I just want to make sure I understand maybe one or two fine points here.
Sure.
Theoretically, if there were no, as it's laid out, the bill says you have to offer to renew except for upon, good cause. And there's a list of number of factors that constitute good cause. If we said that you didn't have to offer to renew, but that we use this same timeline of 75 to 100 days prior to the end of the lease, would we be within our rights to require a landlord to communicate some sort of notification to the tenant, whether that is that we have, that I'm offering to renew the lease, or that I'm not going to be offering to renew the lease. I'm going to take back the premise as is my right.
Actually, that law already exists. It's state law. It's in the city's public local law, and it sets forth the deadline. There's already a timeline, and the landlord must say, the lease is expiring. I'm getting rid of you. So no, the city wouldn't have that power because it's already set forth in the law. If the landlord follows the notice requirements in the city's public local law, that's all they need to do in order to be allowed to get their premise back. And again, I don't mean to be, unsympathetic to this, but this one there's really no way around it. The federal government may have guidelines during a pandemic, but until the federal government passes a law preventing people from being kicked out at the end of their lease, it won't overcome the state's supremacy. I mean, that's the supremacy clause in America. All the power is with the states. And so while the state can preempt the city, the federal government can't preempt the state unless it clearly occupies that topic and does it legally, not just by recommendation. So again, this is really a topic that needs to go to the General Assembly so they can fix the public local law for the city and fix these timelines and fix these notice requirements.
Thank you. Odette, Councilman, if you have another question, I'd like to go to
I'd like you to come back to me if we could. Thank you, Madam Chair.
Sure. Councilwoman Ramos.
Thank you, Madam Chair. And I was kind of wondering, Ms. Ruley, if you had heard the back and forth about the amendments, because it sounds like what you're saying is that whatever parameters we try to put on this thing, we can't do it. But what we're
Right.
trying to do is put parameters so that, we're not evicting people unnecessarily during the pandemic.
I totally
So-
understand, except the landlord has the right to evict the people during the pandemic. So as long as your law doesn't prevent that eviction or change the timeline, you'd be good. I just don't know what that would be. And that's why in this case, we already have a court saying state law guarantees the landlord the right to evict at the end of the lease if they follow the process in the city's public local law, which is state law.
But we can't even put, I'm sorry, Madam Chair, may I follow up?
Go ahead.
We can't, you're saying that even if we try to put in something related to the pandemic?
Absolutely. In other landlord-tenant areas, the city and the state either had concurrent jurisdiction or the state was silent. This is not the case here. The state guarantees the landlord the right to evict at the end of a lease. And the governor has not said that's one of the situations that we won't do during a pandemic. He's prevented with a bunch of executive orders certain other evictions, but he purposely left out tenants holding over at the end of a lease. There's simply no room left. The landlord is given by state law the absolute right to evict, and the pandemic has nothing to do with it. Unless the federal or state government says the landlord does not have that right because it's a pandemic, we're powerless. And I wish that I could come up with a way to amend the law, but you couldn't even force the landlord to talk to someone. It's just all in the hands of the state legislature. They've said in city local law, if you do these things at this timeline, you have the guaranteed right to evict. And I know it's awful during a pandemic because it works a terrible hardship. But even any of the pandemic COVID-related laws that the city has put forth so far, they haven't come up against a state law that guaranteed the opposite. Whether you're talking about like tenant, no rent increase, there's no state law that says the landlord can always increase the rent. But here you have a state law that says the landlord may always evict at the end of a lease. And so the city can't be the entity that enacts a law that says the opposite. And to the sheriff's point, they're never going to know why they're getting a warrant of restitution or what happened in the case. They're going to serve it regardless of what happened in the courtroom. I don't believe any district court will look to this as any reason that a landlord gets to has to keep a tenant in their home. And it's terrible. It's an awful policy, public policy. It's, unfortunately just not one of the landlord tenant things or one of the things during a pandemic that we have any power over.
Thank you.
Thank you.
Is there any other member on the committee that would like to say something before we go back with a question from Councilman Dorsey? See no other hands. Nikki, your hand is up.
I do have a question, Madam Chair. You
Yes.
just mentioned that silence at that the other jurisdictions were concurrent and they had silence at the state level. And so while we do have state legislation that may point to this specific issue, the governor's executive order specifically does not address and is silent to this loophole. Does that not apply? And if so, how and why does that not apply, or does that not constitute silence?
Actually, Nikki, it proves my point. The governor's looked at all the laws that could cause someone to be evicted, or I can't say he actually did that. I'm telling you what a court would interpret. And the court would look at all the laws that could make someone be evicted. One of them is failure to pay rent, right? And so during a pandemic, if you can't get a job, you have a lease, you're living in that space, but you can't afford the rent. That's different than here, which is your lease expired of its own course. It's just a year-long lease and the year is up. And so the governor presumably his executive order not addressing this would be proof that he thought, a court would take it as proof that he thought this isn't one of those situations that I should alter during a pandemic. So I think the court would look at it and say the opposite, because really there are already state laws about evicting people when they don't pay rent, right? And so that's a guaranteed state right. You can evict when you can't pay rent. But the governor stepped in and said during the pandemic, we don't want that. But he purposely didn't step in and include this part of state law. And so he said during the pandemic, even when your lease expires, you get to be evicted. And so the solution here is get the governor to amend the executive order or go to the General Assembly and ask them to change city public local law, which is a state law. Or alternatively, in the beginning of the pandemic, the governor said, look, I may not know everything. I've put out an executive order allowing local jurisdictions to suspend local and state laws if it's in the public health interest. But he removed that power a couple of months ago, and all local laws and state laws that had been suspended during the pandemic will resume on July 1st or whenever they would have otherwise resumed. So he took that away. And so what his actions are saying is, you know, I've acted in this area, and I think a court would clearly interpret that as he meant to preserve the state given right to evict at the end of a tenancy. He did not mean to preserve the state given right to evict when you can't pay or where you have, you know, other reasons for eviction. You know, he didn't suspend those things. So a court would interpret that as intentional and preserving the landlord's right to evict at the end of a lease.
Thank you. Councilman Dorsey, did you have one other?
I realize I don't have any other questions. Thank you, Madam Chair.
Okay, what we're going to do now is there is some public testimony. There's public testimony where some people have signed up, did an advance sign up. Aaron DeGraffery, I think, did you have something to say before we move on?
Yes, Madam Chair. Thank you. I just wanted
Sure.
to add just a couple of things in response to the law department's points here. The two things. Number one, as I mentioned earlier, while I agree that in general the supremacy clause does defer to the states over the federal government in a lot of matters. In this particular case, the CDC has an executive order that explicitly says that that basically it has an eviction moratorium that provides greater protection than what the governor's current executive orders provide. And in that, the CDC order with the moratorium on evictions, it says that this order will apply in all states, localities, and tribal areas where there is a lesser level of protection. And so that's sort of the first point that we think it could be helpful to include and refer to and incorporate in the amendments as we go forward. Secondly, the case law that we have to deal with, that we have to go off of, that lawyers would use going into court to defend this law and use this law to keep tenants in their properties, it's kind of different because this is such a unique time and such an unprecedented time. And so the case law that Ms. Rulli has talked about is true that in the past, very, very similar situations has gotten what for this bill would be bad case law out. But those circumstances in my estimation are not the exact same. This is a rather unprecedented pandemic that we are dealing with. And on top of that, there is a recent case law out of the Eastern District of Pennsylvania where a similar Philadelphia law was upheld. Now, to be clear, the structure of the eviction and landlord-tenant laws is different in Philadelphia and Pennsylvania, more to what Ms. Ruley described as the state being more permissive to allow just cause eviction protections to go in place. So it's not an 100% apples to apples comparison, but it does provide some helpful support to support in favor of Baltimore City taking some action here that again I think we can create an amendment to make this law something that would stand up under challenge.
Thank you. And I agree, we are in different times, a state of emergency, as you say, and hopefully the amendments will kind of help with that. And thank you for reminding us of the CDC executive orders for eviction as well. I'd like to move on now to public testimony, and there were some people that have signed up in advance, and just want everyone to, again, please be patient, use the raise hand function if you want to testify. Make sure you state your name for the record prior to testifying. We are being recorded. And for telephone users, we will get to you as well, and you will hear the 2 beeps. And if you don't want to testify, please indicate that you're not testifying, you're just listening when we go through that. And once again, please state your name for the record at the beginning of your testimony. Please just give us no more than 2 or 3 minutes. And we'll start with the people that have signed up in advance. And if Bridget Simmons, are you there?
Hi, I am here. Can you hear me properly?
Yes, we can hear you very well.
Thank you so much, Madam Chair and the committee, for the opportunity to comment in support of the proposed ordinance regarding landlord-tenant lease renewals. The current public health pandemic has only reinforced the importance of having a place to live. Remaining housed has allowed families to practice social distancing to prevent contracting and/or spreading COVID-19. The Center for Disease Control and Prevention enacted its temporary halt on residential evictions for this reason. And while vaccines have become more widely available, the CDC continues to stress the importance of social distancing as a strategy to decrease the spread of COVID-19. All of the described transmission risk in the CDC order are applicable to renters who must move due to non-renewal of their lease. As indicated in the CDC order, the movement of renters leads to multiple outcomes that increases the risk of COVID-19 spread. And where there has been a need for more protections, cities have utilized their authority to protect the public's health and to minimize any long-lasting effects of the COVID crisis. The proposed ordinance would provide renters with increased notice of the landlord's intent to not renew the lease. Increased notice to renters is necessary because families need the additional time to find new housing, as moving has become more tedious during the pandemic. The ability to quickly lease up is further limited by the housing opportunities available to families. Low-income families will undoubtedly face more hurdles when trying to quickly find new housing after a non-renewal of a lease. For the nearly 98,093 extremely low-income renters, only 34,327 rental homes were affordable and available to families in the Baltimore, Columbia, Townsend area in 2019. According to the National Low-Income Housing Coalition, the Baltimore-Columbia Townsend area has a shortage of 63,766 rental homes that are affordable and available to extremely low-income renters. And where families cannot quickly find alternative housing, the family will face eviction or homelessness. This will subject the family and the public to all the transmission risk intended to be prevented by the CDC order and Governor Hogan's executive order, and will permit as well as encourage landlords to skirt both orders. This has been proven when reviewing Maryland state records. In October 2020, 552 evictions were filed for holdover tenancy, a 117% increase. Previously, these cases made up to 1 to 2% of Maryland's eviction cases. And while we are all eager to expeditiously get back to normal, the effects of this unprecedented public health crisis will continue with us even after infection rates become minimum. These protections are not only essential for keeping Baltimore residents housed, but also to set a firm foundation for the economic recovery ahead. The National Housing Law Project is supportive of the Council's efforts to ensure housing stability by instituting just cause lease renewal protections. We hope that the Council will continue to explore other mechanisms to expand in scope and duration tenant protections. And I apologize, I didn't say, I'm Bridget Simmons, the staff attorney with the National Housing Law Project.
Thank you for your testimony. And next we have Matthew, sorry if I pronounced your name wrong, Losick?
Yes,
Los-
can you hear me?
Yes, we can.
Okay, good afternoon. My name is Matt Losak. I'm Executive Director of the Montgomery County Renters Alliance, Maryland's first and only independent nonprofit organization dedicated exclusively to advancing renters' rights and stability. We were founded in 2010. We provide advocacy, education, and support for renters on a range of issues, such as forming tenants associations, improving landlord-tenant relations, resolving disputes, and pursuing policies to secure fair and predictable rent increases and quality housing. We are also co-founders of Renters United Maryland, the first statewide coalition formed to advance renter protection legislation in Annapolis. Just cause eviction laws require a landlord to automatically renew a lease with the same provisions each term, with the exception of an annual rent increase, absent a legitimate stated reason not to. In addition to substantial breaches of lease, property damage, illegal activities, disruptive behavior, just cause laws allow for non-renewal with proper notice for legitimate business reasons, including removing a unit from the market or renting the unit to a family member, substantial renovation and demolition, provided these measures are done in good faith and not intended as a means to circumvent just cause eviction protection. The Renters Alliance has led the fight to enact just cause protection in Maryland for nearly a decade. While we have not yet been successful in Annapolis, we have built widespread support for a Montgomery County bill, only bill, with unprecedented unanimous support from the County Council and the Executive, as well as the vast majority of the county delegation and Montgomery's major civic organizations. Nevertheless, we have not as yet been able to overcome the obstructionist lobby of the landlord industry and their allies in the legislature, who, even in the face of broad county support and a pandemic, have denied even the local courtesy of passing just cause. We therefore eagerly support Council Bill 210031, Landlord-Tenant Lease Renewal. However, we must concur with our colleagues' testimony at Renters United Baltimore that the bill should include specific, clear parameters for just cause, similar to legislation passed in other regions. We also urge, if you're successful in doing this, for Baltimore City to relate the unique and critically needed interpretation of state law this legislation provides to enact real protections against unjust evictions during the pandemic and long after throughout the state. If Baltimore City is to successfully enact just cause protection for its renting residents, it should lead the way for other jurisdictions to follow suit. Unstable communities have costs that go well beyond human suffering and inconvenience. They have a chilling effect on social and economic participation, harm student achievement, and increase health risks for residents in constant fear of dislocation, especially seniors, working families, and those with fixed and low incomes. Instability also leads to the spread of COVID-19. We therefore urge favorable passage of this bill, and we thank the council sponsors for their leadership in bringing this legislation forward. Thank you all.
Thank you for sharing your testimony from Montgomery County. Next, we have Safar Shah.
Yes, thank you, Chairwoman Middleton, members of the committee. My name is Zephyr Shaw. I'm an attorney in the Human Right to Housing Project of the Public Justice Center, and I'm speaking today on behalf of the Baltimore Renters United local coalition. I've submitted our testimony, our written testimony, signed onto by 19 different organizations. And we support this bill with or without the amendment. We just think this is sound policy. It's even more important today because of the emergency that Baltimore renters continue to be in. I want to emphasize a point. I know that the sponsor, Councilman Glover, brought this context up at the beginning, but I want to reiterate that it's estimated right now that Baltimore City renters are carrying a rental debt of over $83 million. And when you look at the picture of housing destabilization across the state, we're not talking just about an extreme poverty population. We're talking about 1 in 4 renter households. And that's an even higher figure when we're talking about African-American households, which are 30% delinquent in March rent, and Latino and Asian households, which were over 40% delinquent in rent just last month. What we're seeing in this period of heightened threat of displacement is that rent is just part of the equation. And by late fall of last year, legal advocates at organizations like my own Public Justice Center and at Legal Aid and Homeless Persons Representation Project, we're seeing increasingly that renters are facing evictions, not just for non-payment, but because of non-renewal of their leases, even as the state is sending out the emergency rental assistance program money. And we've seen landlords resorting to these lease non-renewals, in some cases, without them actually understanding that they can't obtain the rental assistance after they've ejected their tenant for lease expiration. So we thank the council president and Councilman Glover for leading this bill forward in an urgent time. From our view, this is stated in our written testimony, there is an obvious benefit to individual renter households. But I co-sign on what my friend Matt Losak just said. The benefits at the macro level should not be underestimated. The community, family, education, the sort of dispersed value of this bill that comes about with tenure in a property is so truly important. This bill is essentially about equity, and it's about earning your keep. If a tenant has followed the rules, they get the offer to stay in place, and that's just so important for continuity in our neighborhoods. If they don't follow the rules, then there's good cause not to offer that lease renewal. I want to just make a final point about preemption. And I think that for all that's been said so far, the fundamental point for the council to interpret is whether this bill conflicts with existing state laws or supplements existing state laws. If you look at public local law 9-11 through 14, if you look at Real Property Code 8-402, there is no rights language. There is no guarantee language. There is a procedure of notice and a court procedure after a lease expires for the landlord to repossess the property. That is not a guarantee of the right to evict people. What this bill does is it steps in before a lease expires, before a landlord has acted on any desire not to renew, and says, well, you have this contractual relationship, and as a city, we're prompting that contractual relationship to continue unless there's certain reasons for it not to. And if there is good cause to decline to offer the renewal, then those state laws, the public local law and real property code, are still in effect, and that's what the landlord then resorts to, for instance, if there's a holdover tenant. So this is not a express conflict. I don't think it's even an implied conflict, in my opinion. I just quickly, I know I'm going over here, but I want to just read two different Court of Appeals holdings that I dealt with Baltimore City and I think go squarely to this issue. So in 1954, there was a decision called Huebeck, the Huebeck versus City of Baltimore. And that dealt with the rent control ordinance. And it, as I think was prefaced here by the law department, the Court of Appeals found that ordinance unconstitutional. And the reason for that was because it prohibited a landlord from seeking to recover possession of the property, even if the lease had expired, so long as the tenant remained in possession and paid the maximum rent permitted under the ordinance. So that was 1954, and you have a problem with the ordinance prohibiting the landlord's use of the repossession laws that exist. Fast forward to 1969, you have another Court of Appeals case called City of Baltimore versus Sitnick. And this is what the Court of Appeals explained there. Unless a public law, a general public law, contains an express denial of the right to act by a local authority, the state's prohibition of certain activity in a field does not impliedly guarantee that all other activity shall be free from local regulation. And in such a situation, the same field may be opened to supplemental local regulation. And in that case, the Sitnick case, the court was reasoning that Baltimore City could supplement a state minimum wage law with a city ordinance that establishes higher wage standards than those set by the state. And so I think there's a view here that the city council may well take, which is that the good cause provisions of this bill are simply supplementing what exists in state law, provides a higher standard for what the parties will do before a lease expires, and the bill lets alone the provisions of notice to terminate and the provisions for a holdover eviction in the case that there's not good cause, there's good cause to decline to offer a lease renewal. So I'll end there. We strongly support this bill as Baltimore Renters United. Thank you.
You for your testimony, and just want to say to the committee again that the protections of the federal government is offering during the what they're offering during the pandemic may be even greater than what the state laws address. And we need to see if, when we get these amendments and how they're going to be constructed, if they can, work for the betterment of our city. So on that note, there's the next person is Lee Ogburn.
Madam Chair.
Yes, before we go back to Lee Ogburn, Councilman Dorsey, you have a question or a statement?
Yeah, I have a question for the law department on reflection of the testimony that was just given.
Sure.
If the city, this is a pretty technical question. If the city were to pass this ordinance, despite the law department's report position and an injunction against the enactment of this law were filed and held up by a judge, or a person aggrieved, a landlord aggrieved, filed a suit or whatever. If this were to come to court, the city of Baltimore, the law department would find itself in a position of having to defend our decision to pass this law and defend whatever logic the city council and the mayor used in passing this law. Am I correct about that?
As long as we could do so within our oath as lawyers under the Maryland Rules of Professional Conduct. I know for me personally, I couldn't. I wouldn't recommend that the law department do that. We would probably have to hire outside counsel because, like your previous testimony from the very astute lawyer actually missed page 321 of the case he was citing. and said, there's two lines there that basically says the Hubeck case is one in which an express permission in state law conflicted with local ordinance. It was that in rental cases, you absolutely can't do this. In the case in Sitnick, where they involved something other than this, the court said, yes, in other scenarios, you can add on. And so unfortunately, my license, I wouldn't be able to stand up as as an officer of the court and support it, because I would have to explain to a judge why I've got a 1969 case staring me in the face and telling me that the right to evict is not the same as other state laws where you could add on. I don't know how I would do that. And so I think that the solicitor, I would certainly advise him to hire outside counsel, or we would just have to, maybe enter an appearance and go from there. Again, I'm not going to reveal a litigation strategy online, but I don't, I don't see a way around it. And again, the federal law mentioned is if that gives certain tenants right now some protection, that's great. The tenant would be advocating for that in district court, but it doesn't give the city the right to legislate on the topic. And so again, I completely sympathize with these renters. I wish there was something we could do. And I certainly would have suggested an amendment if I thought it was in any way possible.
Thank you.
Thank you. Thank you, Hillary. So what we're going to do is move on, because I know that some attendees have been patiently waiting. So we're going to get through everyone, and then we'll get back to the committee and move forward from there. So the next person is Lee Ogburn.
Yes, Madam Chair, can you hear me?
Yes, we can.
Thank you. This is Lee Ogburn. I'm a staff attorney at Maryland Legal Aid. We submitted written testimony, and I won't reiterate what we said there. I'll make only two brief points in addition to that. One is that this problem is real to our clients, not theoretical. That is, rent-paying tenants are being non-renewed. We see a number of circumstances in which that occurs. That's point number one. And number two, for a low-income tenant, the consequences of non-renewal are harsh, and they're sometimes catastrophic. Landlords non-renew even rent-paying tenants sometimes when the tenant requests repairs. In the minds of some landlords, it's easier to replace the tenant than to do the work, and they do that. There are 60,000 renters in Baltimore who pay more than 30% of their income in rent. There's high demand for inexpensive housing, and landlords take advantage of that demand by simply replacing a tenant, even when the tenant's paying rent. Landlords replace tenants for no apparent reason. We have a matter where the landlord received a letter from the tenant received a letter from the landlord saying, "We appreciate your tenancy and assure you that this non-renewal is not reflective of your tenancy, but rather the prerogative of the owner." And the difficulty is that it is the owner's prerogative to tell someone that they simply must move, even for no apparent reason. And for a low-income person, the consequences of that are difficult, simply because moving is expensive, and particularly because the security deposit that's required to find a new place is unavailable until they receive their security deposit from the existing place. So this bill addresses a real problem for our clientele. It's not wind addressing. On the legal point, I would say simply that if the city law department is focused on 8402, which plainly provides the right to evict a tenant at the end of the lease, it appears to me at least that what this bill would do is regulate when the lease is ended, not what occurs upon the end of the release. So that it doesn't contradict the state law, it supplements it by regulating the duration of the tenancy, not the rights of the landlord at the end of the tenancy. That is all of our testimony. Thank you, Madam Chair. We support the legislation.
Thank you. The next person, Ari Plott. Ari Plott.
Thank you,
those that have already testified, please put your hand raise sign down. And Ari, you can go.
Thank you, Madam Chair, members of the committee. Ari Plout here on behalf of the Greater Baltimore Board of Realtors in opposition to this bill. I did submit written testimony, and I don't want to repeat myself. And this is the first I'm hearing that there will be amendments on it, so I can only comment on the bill as written. I can't really comment on the amendments until I can share them with our members. But we essentially would oppose the bill because it conflicts with an existing contract between a tenant and a landlord. If there's already a notice to terminate provision, if there's a notice to terminate provision, this is basically saying that that's null and void. As indicated by the law department, there is already a 60-day termination timeline, the notice timeline. So it already exists, but this would basically say that the landlord cannot provide any notice to terminate a contract. Some of the terms of the bill are a little vague. What's a reasonable increase in rent? It's not defined. Substantial breach as well. I don't know what amounts to a substantial breach. But with that, Madam Chair, I appreciate Councilman Glover for sponsoring this, but we respectfully oppose this and happy to work with the sponsor and the committee. Thank you.
Thank you for your testimony. Mark Martin. Is Mark Martin there? Mark Martin going once. Mark Martin going twice. We'll move on to Katherine Howard.
Good afternoon, Madam Chair, and thank you very much for having me. Can you hear me?
Yes, thank you for your patience.
Oh, thank you very much for allowing me to testify. I'm here on behalf of the Maryland Multi-Housing Association. I am their legislative committee chair, and in my day job, I am general counsel to Regional Management, Inc., a long-term member of MMHA. I've heard all the testimony today, and while I agree with the Office of Law, I think they are spot on with regard to their analysis of the state of the current law. One of our concerns is that we believe that perhaps there is a way to navigate something that might be a middle ground here. We did do some preliminary drafting, which we shared with the sponsor. And I think that may be where we will hopefully find some possible middle ground between the stark problems that we see and agree with the law department on with regard to this bill, and possibly finding a way to uphold that law while still putting together a potential affirmative defense that a tenant might use in very limited circumstances for a very limited period of time during the pandemic. I'm not going to go into talking about that in detail because I know we're going to have a work session on it. I do have other witnesses here, Leticia Rollins, who is also an attorney, and Terry Cotton, who is with Southern Management, to give you their perspectives on the proposal as it was written and some of the problems that it has in the practical world. And with that, I say thank you very much.
Thank you for your testimony. And next in line is Leticia Rollins.
Good afternoon. Can you hear me?
Yes.
Thank you so much for giving me the opportunity. I just want to comment on a couple things. My name is Leticia Rollins. I've been practicing landlord-tenant for over 10 years. I've represented tenants. Now I currently represent landlords. One of the things that I think is missing from this conversation, listening to the Office of Law, we certainly respect their opinion and we agree with it. But just in response to what the advocates have stated, one of the practical problems with the law is as follows. A landlord does not non-renew a rent-paying tenant. Landlords love tenants that pay rent. They're their favorite tenant. Landlords often non-renew tenants for nuisance behavior, such as unauthorized occupants in the property, the tenant is smoking, there's noise disturbances in the premises. Those are the grounds that the landlord non-renews. If a landlord issues the notice of non-renewal without, and there's no good cause requirement, the landlord would then appear in court. There would be a hearing. The judge would determine whether there's a lease. Has the lease expired? Did the landlord give the right notice? And a judgment will be entered without a good cause finding. If the good cause law passed as it exists, or even with the amendments, what will happen and the consequences that will come into play for the African-American families and all of the families that everyone is trying to protect is simple. Landlord will issue a notice of non-renewal. They'll state the grounds for the non-renewal. Again, smoking, marijuana, noise, unauthorized occupant in the property. They'll list all of those grounds out. Landlord will go to court. A judge will have a hearing. A judge will determine, is there good cause? If the tenant wins, great. Tenant gets, they would determine that there was no grounds for the notice of non-renewal. If the tenant loses, this is the negative impact. There will be a tenant holding over judgment, and that judgment will be with good cause. What does that mean? That case becomes essentially the same thing as a breach of lease. That means that a tenant now has a negative ruling in their background with good cause that in fact the tenant caused the following conduct that the landlord alleged in court. So how does that play out in the real world? That means that right now, if a tenant is found to be holding over in the property because they didn't move with notice, then they literally get their judgment of tenant holding over. They move, they essentially have, albeit a neutral reference. No one knows what happened in that tenancy. That mom and those kids who may have caused some nuisance behavior can move, re-rent a new home with no issue. Under this legislation, even with the amendments, there will be a good cause finding. Landlords will know, my clients will know, oh, that tenant did have an issue. There was a tenant holding over judgment with good cause. That's an unintended consequence that I don't believe anyone has explained to the council. And I think that's important. I think it's important for the council to understand that although the intentions are good, although we are in the middle of a pandemic, even if we add the amendments that my esteemed colleague Kathy Howard acknowledged, we will have tenant holding overs with good cause as judgments, even during this limited time period, which will have a negative impact on the very families that the council is intending to protect. But I think that's important for the council to know, to understand, and to recognize. We currently have a breach of lease statute. Under that statute, if a tenant is found to be in breach for a variety of reasons, it's a breach, it's substantial material, it warrants eviction. That also is a negative impact on the tenant. The tenant will have a negative rental history because of the findings that are made by the court. Again, I would emphasize that right now, the way that the law currently works under 8-402, there are no findings of fact. There is no analysis. There's no witness testimony, whether the tenant was noisy, whether the brother came to stay for some time, whether the tenant was smoking marijuana. There are no findings of that. It's simply that there was a lease, the lease expired, the tenant did not move, the tenant appears in court, judge enters judgment, and the tenant can quietly, easily move from one landlord to the next. That's my main point that I wanted to share with the council. Another thing that I wanted to clarify is this. There's no other county has passed just cause. So there's been testimony before this council that Montgomery County has passed just cause. I know that there's been a lot of work in that regard. That actually is not the case. Secondly, to respond to what the Office of Laws indicated, one of the things I think is very important, House Bill 104 just passed. It just came out of the state legislature. Under that House bill, they looked at the Section 8-402 and the notice of non-renewal requirement. Under that law, they extended the time period across the state, giving every county in the state the same obligation to give the same amount of notice to every tenant in the state regarding non-renewals. They did not add just cause. They did not add anything to House Bill 104 other than an extension of time requiring that the law be uniform across the state, indicating that if a tenant is on a month-to-month lease, the tenant is to be given 60 days notice. If a tenant is under a year-to-year lease, tenant is to be given 90 days notice. That law becomes effective October 1. So to take a look at what the state legislature thinks of the non-renewal law, it's right here in House Bill 104. We don't have to glean or imagine because they literally just looked at this law in this current session. And so when the Office of Law indicates that, in fact, the state law has been evaluated, looked at, Governor Hogan looked at the various laws and made a decision on what should be protected during the pandemic. I think House Bill 104 also gives guidance in that regard, that in fact, the state legislature also looked at the non-renewal notice requirements, and this is what they came up with. I think it's interesting that there's a notion that the CDC will provide an escape. There will be no escape through the CDC. Judge Morrissey of the District Court already gave the attorneys and the landlords and tenants guidance on what will happen if we were to evaluate a CDC declaration. Again, Kathy Howard, my colleague, recognized the fact that that will be raised as an affirmative defense. That means that if a tenant has been substantially impacted by COVID, they are still required to come into court. They can raise that as an affirmative defense. I would ask the council to consider the amendments that are going to be proposed by Maryland Multi-Housing Association. But I think everyone should really keep in mind the negative impact of a good cause finding in a tenant's background. Thank you so much for your time.
Thank you for your testimony. And, we're here for everyone to give their testimony, and we're not really debating testimony right now. We're gathering all of the testimony and I think the committee is looking forward to these amendments. I know they have gathered some good information. And Nikki, I see your hand up. Did you want some final comments?
I did have some follow-up questions based off the final testimony, but I'll touch base on it.
Because there's no, at this point, we don't see anyone else that wants to testify. Nope, no more. We have, that's it with the testimony. So Nikki, did you have anything else to say? You or Aaron?
I did want to just make a couple points, because some of the issues that were raised, we have with both Councilmember Glover's office done our due diligence on looking at those issues, specifically raising to the point of an additional negative record if you follow through the just cause process.
I do see Jamal's hand raised, and also Bill Wells from the Housing Authority, and then also Odette Ramos, a member of the committee. So we'll go ahead. Jamal, you took your hand down. Did you?
I'll just wait to the end, Madam Chair.
Okay. Bill Wells, did you want to go ahead, and did you have a statement to make? And then Odette, you can go after Bill.
I did. Thank you, Madam Chair. And I hope, Nikki, that we can have an opportunity to also have some impact on the crafting of any amendments. Again, I wanted to point out that the Housing Authority serves Baltimore City residents through two main programs: the public housing program, where the Housing Authority is the landlord, and the Housing Choice Voucher program, where the Housing Authority administers the HUD funds as housing assistance payments to private landlords. And the impacts of this legislation would be slightly different for those two programs, since the Housing Authority is not party to the lease for the voucher participants. We wouldn't have any direct connection there. However, we are concerned about unintended consequences to voucher participants who don't wish to renew their leases. And in our experience, many voucher holders, for instance, in the first period, the first year that they have a voucher, they must be on a year-long lease. They do have the option afterwards to be on, and some prefer, a month-to-month lease, because that voucher allows portability for them to go and look for another residence at their choosing. So they can move their voucher to another landlord, another residence. Making automatic renewals a requirement could therefore negatively impact voucher families if it were to lock them into an automatic renewal when that's not what they wanted. So I wanted to raise that. I don't know. Of course, the Housing Authority in some of these instances has said, and I would reiterate again this time, that the spirit of this law is part of the policy and practice of the Housing Authority in both programs. We would ask to be exempted from this legislation for that reason. That would certainly clear up this potential problem for the way some of our voucher holders do use their vouchers. The other issue for voucher holders is the 75-day notice provision. That would be difficult for the Housing Authority to administer. Our program adheres to the Maryland State 60-day notice requirement. So the period, for instance, for a voucher holder to look for a new unit is 60 days. So that fits in very well. That voucher, essentially, once it's issued, is good for 60 days. There are ways that it can be extended if the tenant is having difficulty finding another unit. But to have that 75 to 100-day notice period could place a burden both on processing on the Housing Authority side, but also on tenants, that they might have vouchers that they were taking to use that would be expiring even during that period. So that's the housing choice voucher side of it. The public housing side is much more straightforward. The public housing has automatic renewal of leases. Public housing, are not, and this gets to a technical difference in what law cited. Law cited 9/11 in their response. Public housing and HCV leases use instead 9/14, which provides for 60-day notices as the requirement. HUD regulations mandate that leases in public housing be automatically renewed. So to our standpoint, public housing already has the provisions that are requested or that are trying to be solved by the legislation. So while we do have concerns about not knowing what the amendments that are being proposed by other groups or within the council, we would like to be removed from this legislation. And if not removed, then at least have the legislation drafted or amended in a way that it wouldn't conflict with the way our programs currently operate.
Note well taken. Thank you.
Thank you.
I'm trying to, okay. Councilwoman Odette.
Yeah. Thanks, Madam Chair, and thanks everyone for this really great dialogue. I'm learning a lot, so I appreciate it. It's my understanding that if there is a judgment on someone, that they don't say what the judgment is. So I think that's something that we have to consider when we talk about the points that that Ms. Rollins made. But also I'm wondering, and this might be to Ms. Ruley, you might potentially have a fair housing issue here if the landlords have the absolute right and we can't put conditions on when somebody can be, the lease can't be renewed. It sounds to me like we're teetering on a fair housing issue here.
That's interesting. There can be conditions. They just can't be put in by the city of Baltimore. There are plenty at the state level, and the state has separate public local laws that it has enacted that apply only in Baltimore City. The 9/11 that was just referenced by HABC is sort of the overarching. It actually also encompasses 9/14, and there's like 2 pages of exactly what they are, when you must give notice, what it's for, when the notice applies, like when during the tenancy. There's plenty of requirements. It's that the General Assembly has prevented local governments from impacting this right. We can't conflict with that. If we didn't have public local law and we were just going under the state law, then sure. But we have public local laws in Baltimore City that already cover this entire topic. And so we can't conflict with that. So not only can we not take away the right to evict someone, but we've got 2 pages of public local law that says exactly how to do these notices when they come, the caveats, how it work. And so that's what we're up against.
You're breaking up, Ms. Ruley, you're breaking up.
That was it.
Oh, okay. And then, Odette, you had another question?
That's okay, I'll take it offline. Thank you.
Okay. And so then we have Jamal Simmons from the sponsor and Councilman Glover's office.
Once again, good afternoon, everyone. Councilman Glover would like to thank everyone for their input, hard work, and attention to detail in the area of this bill. Choosing to add to this housing crisis in this unprecedented time is not an option. He looks forward to working with the legal minds to craft amendments that are going to protect our families. He believes his job as a councilman is to craft laws that protect and raise up some of the most vulnerable citizens, and will continue to fight in this housing matter. Thank you.
Thank you for that, Jamal, and we hope that Councilman Glover gets well soon, and we'll keep him in prayer. And on that note, do we have anyone else that has something to say before I go to a recess? At this point, seeing none, we're going to, so it looks like there are going to be some amendments put together. There's going to be dialogue, especially with the sponsor and the council president's office. And this is a format that we continue to follow. And the committee, you will, I'm sure, you will be getting the amendments in advance, and we'll also let you know when we have our date scheduled for the work session for these amendments. Thank you so much, and we are now in recess.